So Aurora, I want to give the floor to you now. Aurora is Professor of Intellectual Property and Human Rights at the University of Bristol Law School. So we're going to stay within the IP theme here, and much looking forward to it. Thank you. Aurora, please.
Thank you very much. Let me see whether I can share my screen with you. Can you, hold on, sorry, share screen. Right, it's this I want, isn't it? And this. Okay. Are you all able to see the PowerPoint slides? Oh, can you hear me? Yes? I seem to have lost the sound as far. I can't hear you, but if you can hear me, we'll just move on from here. Okay, well, thank you very much once again, Helle, for the invitation to join the symposium, and also thanks to Ed for in some ways clearing the ground for me to talk about IP and the right to science in international law. And thank you especially for making IP so accessible, Ed. It's really quite difficult, I think, for most of us who are not scientists or indeed intellectual property experts to engage with the both the copyright and the patent system. And in some ways, part of what I wanted to do today, I think, talks to some of the issues, Ed, that you raised at the beginning of your presentation on what you thought were the perceived sources of conflict between IP and the right to science. You pinned down to issues of accessibility, or you're actually identified as accessibility being one of the key problems here. And it's, in fact, accessibility that brought me to the whole problematic of the interaction of intellectual property and human rights. And I'll just say very briefly, before I get into the talk, how I came into this field myself, because my background originally is in philosophy. I spent a long time, 10 years in philosophy before moving over to law. And then in law itself, I did not specialize in IP. I only came to IP very late in my career because of my involvement in the ethics, bioethics, regulatory issues relating to new biotechnologies. So it's because I was brought into projects which were looking at specifically the ethics of stem cell research that I came into the whole field of IP, and I ended up being involved in a project where I was the PI of a project which was funded by the European Commission, which looked at moral exclusions on embryonic stem cell research. And of course, once you get into that field, you just then have to look at the commercialization of this research, patents on stem cells, and so there was a very steep learning curve for me to find out precisely what was happening in this field, who was patenting what, and you know, the related moral issues. And the thing that really struck me and that got me in a way onto this path, you know, that I've followed since, is that it was very, very difficult to establish and find out who earned what in the UK. So one of the aims of the project that was funded by the Commission was to try and establish and find out who earned embryonic stem cell patents in Europe. And we had a team of researchers trying to establish this. We had the resources to question the various databases to find out, you know, who earned what. We had some of the world-leading stem cell scientists involved in helping us doing these searches, specifying terms, to try and generate all this data. And what we found, we thought at the time, was that there were a number of patents which had been granted here in the UK. We published a paper in a leading scientific journal saying, guess what, there are here in the UK, I think it was 13, embryonic stem cell patents have been granted. Whereupon I got a phone call from the UK Intellectual Property Office telling me, actually, we've granted 32 or 36, I can't remember the number, twice as many as we originally thought. And it just got me thinking, how come we actually were so far off the mark? How come we did not, get the full picture here? And that, from one question to another led us to, led me to actually look into, how these patent databases function, how scientists themselves engage with the patent system. And in fact, at some point, I ended up with a PhD student who specifically did her PhD on stem cell scientists' engagements with the patent system. And one of the things that we found and came out of all this research is that the scientific researchers, the stem cell scientists, on the one hand, were either indifferent to the patent system, they were not interested in using it as a form of reward. As far as they're concerned, they were working in, the vast majority of them were working in universities, they got a salary, they're interested in their research, they did not see the point. They did not need to have patents as an incentive or reward for what they did. Of course, some of these scientists worked as well in the private sector, and it was, typically the companies that employed them, which would commercialize the results and, taking the profit on the inventions. But the other thing that, that particular community thought is that actually the patents were getting in the way of their doing the research, because their experience in that field, which was very upstream at that stage, there weren't really at that stage any applications. People were just looking at how cells develop, how they multiply. This is all very high-level research, not of any direct, immediate, practical application. And their experience was that the patents were getting in the way of their doing science as they're used to do, because they could not share in their knowledge, their work in conferences, for instance, until they had filed an application. And we know there are stories in, for instance, of Yamanaka, who got, one of the famous patents on iPS cells, that he actually worked in a lab which was completely closed to all his staff, so that they would not, get wind of what, of his, findings ahead of his filing the patent. So there are, I think there were at the, the sense I got at the time working with that community of scientists is that that patents in that field at that stage of the science were actually more of an obstacle than a spur to innovation. And yes, indeed, as you said, the courts, can actually have the capability and can intervene to tweak and adjust, and come, maybe to try and achieve some fair results. But, see how long it took, for instance, in the United States and in Australia, where patents were granted on the BRCA genes for the courts ultimately to reverse, those patents. The cases had to go all the way to, in the United States, to the US Supreme Court, in Australia to the High Court. They were funded along the way by the American Civil Liberties Union in the United States and by pro bono groups. The resources that civil society had to challenge all these patents, frankly, were not on a par with the resources that the private sector, and in this case, the Myriad kind of company had. So yes, of course, the purpose of all of us engaging with intellectual property ultimately is to try and facilitate ways of tinkering, to use the word, the system to achieve better outcomes. But and what we're doing here today is part of this exercise. But I think maybe I just don't want to sound horribly kind of negative and pessimistic. I just wanted to just bring in a bit of my own experience into this, to just maybe just weigh into this very upbeat kind of an optimistic set of proposals that you made. So having said this, I'm probably going to have to rush through all these slides now in order to be able to complete on time. But what I wanted to do in this talk, and in some ways Helle has nicely preempted the way, because I was going to at some point talk about IP and what IP does, and and how you you kind of what the essence of IP is, and how it compares to human rights. What I wanted to do is to share with you some of the work I am. I've just started really, relating to the justifications of property rights as human rights. So I just wanted to look. I have been looking at how one could justify morally, really, philosophically, the idea of private property, and in particular the right to private property. And the reason why I've begun to do this is because one of the puzzles that I have had for a while is relates to, on the one hand, the provisions that we have in international law, which in Article 27 and 15, which we're all familiar with here, relating to the right of everyone to access the benefits of science, and of course, these provisos that everyone also has the right to protection of the moral and material interests, of the works of which they are the authors, and that is reflected as well in Article 15. So that seems to invite us to think about balancing the rights of authors and inventors as human rights to the rights of the public to access the benefits of science. And we know from a series of reports that have been published, and you've all kind of, we're all familiar with this, that ECOSOC, but also the rapporteur, Farida Shahid, who's reporting Article 15, and various other, and to some extent UNESCO, have actually acknowledged that whatever it is that Article 15(1)(c) means, or Article 27(2) means, it doesn't mean that intellectual property is a human right. And, the reason why intellectual property is not a human right is because, as you would say, prima facie, intellectual property is a right which is limited in scope, in time, as we heard before. And here are examples of IP. Ed has given us many examples, so I'm not going to take you through all this, but clearly the thing that, as Ed said, that is distinctive of intellectual property rights is that they confer on the holder of the right a right to exclude everyone else from use of the IP, and of course the right as well to commercialize the intellectual property. So, so if that is the case, then the question, one of the questions which arises is, why do we find still in in international kind of instruments and comments and guidance like ECOSOC's comment on the right to science, why do we find references to a balance having to be reached between IP and the public rights of access to science? Why talk of balance or of harmony and lack of conflict in this case? To some extent, you'd think if IP is not a property, is not a human right, then why does the Universal Declaration of Human Rights then assert that or proclaim that everyone has the right to own property? And indeed, the European Convention on Human Rights, much, even more, more interestingly, talks about protecting the enjoyment, everyone's enjoyment of possessions, and this, which is understood to refer to property, and this right in the convention is extended not just to human persons, but to legal persons. So we've got a human right here to property, which is proclaimed in the declaration and is specifically extended in the European Convention on Human Rights, not just to persons, but to companies as well. And of course, intellectual property is a form of property. So the question then for me is, are we actually, to try and clarify and understand whether we are balancing here human rights? Is it the case that what we're having to do here is to try and find some equilibrium between, on the one hand, a human right to IP, and on the other hand, a public right of access to the benefits of science and intellectual property? And, if as part of this question, then are we actually, trying to understand, the idea that companies could then be victims of human rights violations if under the convention they have a right to property, which they do. Now, that idea, the idea that companies have a human right to property, I think is particularly problematic, I think, for many people who've followed the conflict that arose over the following the adoption of the TRIPS agreement, and of course the the pharmaceutical companies, the 39 pharmaceutical companies, which sued the Mandela government over the import of generic drugs from India. And sought to assert their intellectual property rights over these drugs against, clearly, or in contrast with the human, the right to health of these populations. Now, if you haven't seen the documentary "Firing the Blood," I can only recommend it. It's a very powerful film which brings home very clearly the drama which unfolded then over the access to antiretrovirals and the behavior of the transnational corporations in frankly taking to extremes their own the right to commercialize and make profit from their own IP. So I think there is prima facie that appears to be a tension, to put it mildly, if not an outright conflict between intellectual property rights, and trade. And this, of course, this tension, if one doesn't want to use the term conflict, but this tension has been you know, just discussed and you know, and it's been mentioned in many reports, including the UN Secretary General's high-level report on access to medicine. So this is not kind of, so that's the background then to my, as it were, excursion into what is now going to be a very abstract and theoretical kind of, you know, kind of, you know, path, because this is back to my kind of philosophy background, you know, and really I'm just trying to, this, you know, the aim here being to try and understand, you know, whether we can ultimately provide a justification for a private right to property. Is this something that is, you know, feasible? And so I've spent the past few months really going back to all these property rights theories, Locke, Hegel, you know, you name it, all these what appear to be rather abstract theories, as part of a project which is now funded by the Leader-Young Trust, who very generously funded a major, given me an award for a major fellowship, research fellowship on intellectual property and the human rights of companies in Europe. So the project it aims to investigate both the rationale for the ascription of IP rights and human rights to companies, particularly in the convention, in the European Convention on Human Rights. And so I'm supposed to be looking back to both the history, the drafting history of this first protocol, the rationale for the ascription of property rights to companies, and ultimately the jurisprudence of the European Court of Human Rights and the Court of Justice on IP rights. So I'm at the early stages of this research, and I'm just trying hard to think, can we justify property rights? Can we find a way of justifying the view that everyone has a right to property, and particularly private property? And of course, when you begin to look at justifications for property rights, you go back straight away to the Enlightenment, because that's where you know, we have the idea of liberty, property, life, you know, as main rights, which came to be constitutionally protected in the 18th century in many constitutions, the French and, you know, the US Constitution, to name, but you know, the most obvious ones. So you have, for instance, in the French Constitution, the idea that every novel idea whose realization or development can become useful to society belongs primarily to him who conceived it. It would be a violation of the rights of man in their very essence if an industrial invention were not regarded as the property of its creator. So here we've got the idea that IP is not, intellectual property rights are not, they're not a reward. They're just there simply as a right, as a basic right, to reflect the fact that you know, that particular work, you know, was the creation of this, you know, the particular individual. And that idea of that property rights are fundamental rights was, of course, originally defended primarily by John Locke, you know, as part of the labor theory, the idea that, you know, Locke's idea, and I'm sorry because this is all sounding awfully kind of trivialized, and if you're interested in the very nitty-gritty of all this stuff, I do have a very long draft which is very detailed, which I'm very happy to share with you. But I don't want to trivialize, but basically Locke, you know, argued that I am, I as a human person, I'm in control of my own body, and in effect, the things, the physical things that I work on are part, as it were, an extension of my body. So I am the master of my own body, and so, you know, by extension, I should be the master of that which I create with my body. And all this because ultimately, you know, we are all part of God's creation. So this is all, you know, ultimately justified by natural law. And there are all sorts of, as you can imagine, you know, and I'm sure many of you are familiar with all the kind of problems with natural law theories and Locke's labor theory. Of course, you know, it was heavily criticized by Jeremy Bentham, who talked about human rights being nonsense, and it's been nonsense upon stilts. You know, the idea itself that I own my body, or that, you know, is just not very coherent, I think, as many commentators have argued. So that's not really a very promising way forward. So we've got instead, and I've moved on. I mean, this is just, I'm sorry that I'm just to be, you know, just summarizing everything at such a, you know, kind of, you know, in such shorthand. But personality theories are important in intellectual property law because they're often used to justify copyright. And here, really, we have to go back to Hegel, which, I mean, I don't know whether many of you recall as part of their excursions into political theory and various types of political theory. Hegel's writings are incredibly obtuse. I'd forgotten how very, very difficult they are to read, and not to say incomprehensible in parts, but essentially, again, to somewhat trivialize, Hegel, I think, is credited with the idea that we can think of that property is necessary as a, because it is through that which I work on with my, you know, which I work on, that I express myself. And it's through, therefore, these works that I produce, which I both achieve a degree of self-development, but also that I gain respect and recognition from others. So so Hegel's in Hegel's system, property is necessary for individual, you know, self-development, and it is also ultimately necessary historically for societies to facilitate that, you know, development generally. Now, the thing with Hegel's theory and the personality theories that are being invoked in intellectual property is that they're not really, I mean, they're just in some ways just taking Hegel's theory in its part of it and just forgetting about many other dimensions of what Hegel says, which are quite important to situating and contextualizing property in his system. And the point I think here to take out is that even though property may be necessary as a way, or at least at some minimum level of property, of private property, may be necessary for individuals to achieve a degree of self-development. Hegel is very clear that the individual is not isolated from the rest of society, that their development is interconnected with the development of society at large. And so unless, and so then he is, in fact, it goes into quite a deep analysis of the way in which industrial societies, and particularly at the time, we're talking about advanced industrial societies like England, had generated, circumstances, a situation where large numbers of persons, of individuals, ended up propertyless, in abject poverty, whilst others were able to accumulate ever more property. And that, of course, is a huge problem for any justification of property rights. I think it's, just to echo Jeremy Wharton's book on private property, any kind of justification of property rights ultimately has to somehow contain, or at least find a way of explaining why it is that it's just it's not acceptable, and it wouldn't be morally acceptable to have 1/10 of the population accumulating huge amounts of property, whilst the rest, the 9/10, are in abject poverty. That's just morally unacceptable. And so that takes me to the background to the adoption of the first protocol in the European Convention on Human Rights, because of course what happened in the run-up to the adoption of the convention, and indeed just 2 years before the Universal Declaration of Human Rights, is that there was talk and the 4 freedoms enunciated by Roosevelt became very much the kind of background context in which the human rights were actually being discussed, and of course freedom from want specifically was one of the ones that here comes to mind, that relates to the extent to which property rights are or should be not pursued in an end as ends in themselves, in an ideal world. And what we find then with this idea of the 4 freedoms is that Roosevelt really, to some extent, tends to run together the idea of, or blurs maybe the distinction, the idea of, on the one hand, promoting freedoms to trade, so the removal of trade barriers, and tariffs, which potentially, it came to be thought, or all these protectionist measures, which it was thought at the time had partly been the cause of the massive depression and unemployment that was taking place. So these ideas of trade freedoms, removal of national barriers, all these ideas then come to be, to some extent, blurred with the ideas that you get into the political economy vision you have also at the time, being floated by maybe one of the most prominent neoliberals at the time, Hayek, in his idea of the road to serfdom, where economic freedoms, market freedoms are actually in some sense equated with individual liberty. Individual liberty then becomes the big rallying crowd claim, but it's actually then being used as well. The whole concept of freedom then becomes the vehicle through which all these justifications for the various rights that are contained in the ECHR and before that in the UDHR. It's that big concept to which everything is being channeled. But of course, it just, it's actually a blur. It's now bringing together a lot of quite different ideas about what the political economy of democratic societies ideally should look like, with the just, you know, the type of political order that obviously was terribly objectionable at the time, because of, you know, what was happening or what had happened with the Nazis. So you have this, you know, talks about rights to property, the freedom of the individual to you know, to earn property and to do as part of his or her freedom to do what, you know, to develop as a free individual, but that becomes merged into the political rhetoric against communism, which is something that really the kind of European leaders are in the grip of at the time the convention is being discussed and adopted. And so what we have then is this kind of blurring, really, of these different realms of individual freedom, the idea of self-development with trade and market freedoms, which are macroeconomic kind of policies. All of this gets bungled together and as a background to the adoption of this first protocol. So, I mean, obviously that's work at the moment that for me is very much in progress. I'm, you know, I'm in the process of, you know, going quite a lot deeper into this. But where I've got to so far there in relation to this idea of economic freedoms and human rights is that, well, it may be possible to justify a human right to property as something that's necessary for individual human freedom and self-development. And that's work in progress. So it may be possible to say, yes, everyone needs to have a minimum of private property in order to achieve a degree of self-realization. However, individual and social and economic development are interconnected. You know, the individual is not an island. The scientists who are researching are building, you know, quite the shoulders of giants. They're part of a scientific community. They are actually, you know, relying on the knowledge that's, you know, that's accumulated over the years and the sharing of that knowledge in order to develop their own thoughts further and to innovate. IP rights are most definitely legal rights. They're not human rights. Possibly you could argue that's what, you know, and I've written quite a bit on this, on what the drafters of the Article 27 and 15 meant, you know, when they talked of moral and material interests of authors and inventors, what they appeared to have in mind then was the idea that authors, inventors had a right to have their work attributed to them, and that was an important, you know, point at the time, because of course on the at the time in France particularly, publishers, it seems, were abusing their contractual rights and were interfering with the integrity of, you know, their writers' works, or not even publishing their names. So you could talk about moral rights. You could.
Aurora, I'm sorry, but it's now 12 o'clock.
Okay.
So could I ask you, please, to just wrap up?
Sure. Sorry about this. So just briefly then, so IP rights then I think are essentially instrumental rights. They're legal rights. They're not human rights. That they could be and they should be working potentially instrumentally to further human rights. And so really, that's why I've actually put them here at the bottom of the balance, because rather than on the scales themselves, because they are tools which potentially society, economic tools that may be used in order to facilitate innovation and to facilitate social and economic kind of progress. But in and of themselves, they are legal rights which need adjusting, which need tweaking, which need to be, you know, just evaluated and critically kind of examined, as we are trying to do now. Thank you.